Hi, I'm Sheila Kuehl, and this is Get Used to It. Today we're going to talk about something that happened in recent history. We were fortunate enough to live in a time when the United States Supreme Court seems to have said that we were human beings entitled to equal rights. We're not exactly sure what the rest of that opinion was about, but in Roemer versus Evans, I think we saw enormous reason to celebrate. And I have three guests here today to talk to us about that decision, about what it was really about the Colorado Amendment 2, and more importantly, I think, the potential impact, if any, of the Roemer decision on the rest of our lives. The military issue, the marriage issue, our personal issues. What did it do to the Hardwick decision? And I'm very pleased to have three incredibly brilliant people with me today. Of course, what else on this show? First, the supervising attorney of the Lambda Legal Defense and Education Fund of the Western Regional Office, John Davidson. John, welcome.
Thank you, Sheila. It's nice to be here.
Thank you. It's good to have you. Skye Johnson, who is the Director of Public Policy and Communications at the Los Angeles Gay and Lesbian Community Services Center. Welcome, Skye.
Thank you. Great to be here.
And Mary Newcombe, one of my favorites. Mary, welcome back. So glad you're here. Who's now a partner in the law firm of Hedges and Caldwell and was the founding attorney, supervising attorney at Lambda Legal Defense and Education Fund here in LA. So welcome all three. John, let's start with you. I don't know whether people really know much beyond the headlines. What was Roemer all about?
Well, Roemer versus Evans involved a challenge to Colorado's Amendment 2. What Amendment 2 would have done had it gone into effect is to say that lesbians and gay men and bisexuals in Colorado could not obtain protection against discrimination, period. It would have repealed existing anti-discrimination laws in the cities of Boulder, Denver, and Aspen, and repealed a number of state policies that protect lesbians and gay men against discrimination. And the only way that lesbians and gay men and bisexuals in Colorado would have been able to secure protection against being discriminated against based on our status, based on our relationships, or based on conduct, is what the initiative said, would have been to re-amend the Colorado Constitution. We couldn't have gone to our state senators or assembly people there. We couldn't have gone to local government officials and asked them to do something. Couldn't even gone to local police department and said, please do something about hate crimes and do something to protect us against various forms of harms to us.
So other people would have still been protected under hate crime statutes or anti-discrimination statutes. The amendment just said very specifically, anybody can be protected against discrimination by cities and counties in the state, or anybody, just not gays and lesbians.
Correct. And one of the things that was particularly ironic about it, it didn't even say that you couldn't have a law that prohibited discrimination based on sexual orientation. And so some people had thought one of the effects of the Amendment 2 would have been, had it gone into effect, that somebody who was heterosexual who was fired from their job for being heterosexual could have brought a lawsuit about that. But somebody who was gay or lesbian who was fired for that reason wouldn't have been able to. And so it was always somewhat funny when they talked about, use this rhetoric of special rights. What it really did was impose a special disability on lesbians and gay men to say, we couldn't get protections that everybody else could have. In fact, we couldn't even have the protections that heterosexuals would be allowed to have in Colorado.
Well, they characterized it as special rights because of this sort of disinformation program that I think the right has been promulgating all around the country, that if you are protected against discrimination particularly, there's something special about that because people who wear glasses or people who are left-handed, etc., are not protected by these laws, which seems to me to be quite disingenuous because people in those categories don't need as much protection since they're not being discriminated against.
One of the wonderful things, and I think there are many wonderful things, in Justice Kennedy's majority opinion in the U.S. Supreme Court was that I think he's really put an end to this deceptive rhetoric about special rights. He, in fact, says that there's really nothing very special about the right not to be discriminated against. It may be a right that some people are fortunate enough not to need because they never experienced such discrimination. But the laws that we have unfortunately we only have them in 9 states in the United States still, but in those 9 states, they prohibit discrimination based on sexual orientation. Now, everybody, whether they realize it or not, has a sexual orientation. So everyone is equally protected against that discrimination. There are no people who get something special that other people don't get. We're all equally protected against such discrimination. Now, some people may not need that protection as much because they're a part of the majority and the dominant part of the society. But everyone ends up being equalized by these rights, and that's what's really, I think, troublesome about this rhetoric, that there's something special about being able to stay in your job and not being fired simply because of who you are, but also this idea that you're getting something that other people don't have, which is simply untrue.
Well, and it also kind of brought us in line, it seems to me, for with some finality, with kind of traditional civil rights notions.
The opinion is really a beautifully written opinion, I think. It starts out with a citation to the dissent in Plessy versus Ferguson. And that was a horrible decision, one of the real black marks on the Supreme Court, where they had said that separate but equal was okay. And Justice Kennedy starts with a cite to the dissent in that opinion that said, no, really, the Constitution does not allow you to treat different classes of people differently under the Equal Protection Clause without there being an adequate justification for it. And then the opinion ends with a cite to a series of cases called the civil rights cases. And so it really brackets the struggle for lesbian and gay rights as squarely a civil rights issue.
Now, the way that the court has decided over a long period of time to give some kind of content to the requirement in the 14th Amendment of equal protection of the laws is they've created a kind of a different tiered system, so that the more serious they think the discrimination, the more important a reason a state has to have to do it. Because this, after all, the Constitution really only bars discrimination by states. I mean, it's not about private behavior so much.
Right, and I think it's important that people understand that this is a decision about the limitations on government action, not necessarily limitations on private action. I mean, it was an important decision in saying that governments can pass laws that prohibit discrimination based on sexual orientation by private businesses. But at the same time, it didn't say that they had to do that. And our political work still remains to bring that about in the remaining 41 states. But what it did say, and I think what people need to understand about the Equal Protection Clause and the court's role in that, we have a system of government that's a constitutional democracy that has checks and balances built into it. One of the roles the court plays is to look at legislation passed by Congress or by state governments to see if maybe there was something illegitimate going on, to see if they overstepped their bounds. And what the court has figured out is that there are some sorts of situations where they should be more suspicious that what the legislatures or the people did, even the people in initiative did, was something that they really shouldn't have been allowed to do under our Bill of Rights.
But they weren't very suspicious in looking in Roemer about this. I mean, I think this is something that our community has said, you know, isn't it just like race? I mean, shouldn't it be an absolute standard that you don't discriminate?
Well, they really, the U.S. Supreme Court has never decided yet the issue of what level of scrutiny is appropriate for deciding discrimination based on sexual orientation and whether it should be treated exactly like race or not. What they decided in this case was that even at the lowest level of scrutiny that would apply, it's been called the rational basis test, Amendment 2 didn't meet that. And I think it's important to get there. They had to decide several very important things. One is they ended up deciding that the same way of analyzing discrimination claims that applies to any differential treatment of groups of people by the government applies to lesbians and gay men. Now, I know that may seem like a very simple and not so important thing, but I'll tell you, after having litigated lesbian and gay rights cases for almost a decade now, we constantly face kind of a gay exception when we go to the courts, and courts really not being willing to treat our claims with the same level of seriousness and with the engaging in the same way as they would other claims.
Well, it's kind of an historic thing, though, John. I mean, when Ruth Bader Ginsburg, who coincidentally is now on the court, first started litigating the gender discrimination cases, and she did all of the early gender discrimination cases. They were hoping to even get gender into the 14th Amendment, because before that, the justices had said, no, now wait a minute, our theory about equal protection is you cannot, as a state, treat similarly situated things differently.
Right.
And they solved it by saying, men and women, we're not similar, please go home. And so it wasn't even a problem for the 14th Amendment, and could have said, and indeed I think in the past have said at a lower level, that's the same thing about us.
Right.
We're not similarly situated. There's such good reason to discriminate against us. I mean, did you read the entire decision and see any reference to Hardwick?
No. One of the things that's
that
interesting,
was strange, wasn't it?
One of the things that's very interesting is the majority decision does not refer to the Hardwick case, which is the Georgia sodomy decision 10 years ago, where the U.S. Supreme Court said it was okay under the Constitution, the U.S. Constitution, for a state to criminalize sodomy. Now, one of the things that's interesting is that case has been used against us, every lesbian gay rights case up to now, and it was clearly used in Justice Scalia's dissent at some great length in this decision. But what I think is important is that the court really put to an end, I hope, the argument that just simply because there could be laws criminalizing some sexual behavior, that doesn't mean that we're not entitled to equality. First of all, most of the sodomy laws in the United States that still exist criminalize certain sexual acts regardless of the sex or sexual orientation of the people engaging in those acts. They criminalize oral or anal sex and don't limit themselves to acts that lesbians or gay men might engage in. And so there's, I think, a misunderstanding that Scalia continues to try to play on. One of the things that's important is prior cases have tried to define lesbians and gay men by our conduct, and particularly by a specific small amount of our conduct. So only sexual conduct and only certain sexual conduct that we may or may not engage in that some heterosexuals engage in too. This decision said no. This was discrimination on the basis of status, and that was a major leap forward for us. And that said that as a result of that, Hardwick, which was a decision about conduct, was really far less relevant to deciding equal protection cases, and that will be very important in our drive forward for equality. But the thing that the decision went on to do was to say the same rules apply in judging us. You need to look at why are they treating lesbians and gay men differently from heterosexuals. And in doing that, the court said that no group of people shall be strangers to the Constitution. It's our Constitution too. And I think a lot of lesbians and gay men who read the decision or read that part of the decision felt very emotional about that. I mean, that was a really affirming thing in the same way we frequently, if our families will still say, you're still part of our family. It really touches us in a way, and that's kind of what the court was saying. But they then went on further to say that in order for for government to treat us differently, it needs to at least have a legitimate reason for doing so. And the kind of coup de grace on it, the crowning glory was, they said that animus against, or animosity against lesbians and gay men was not a legitimate reason to treat us differently. Now that's, I think, one of the most important parts of the decision. What we'll see out in decisions yet to come is lower courts and then ultimately the Supreme Court again telling us more what they mean by that. But what we have argued for years is that that moral opposition to homosexuality is not a legitimate justification for denying us equal citizenship and equal rights. And this opinion, I think, paves the way for establishing that as the law of the land.
Well, I think that's what people have referred to as the beauty of the Constitution. I mean, I love it when it works. And it takes a while to work. And of course, there's a lot of public opinion, and there's a lot of work that goes on before it. Thurgood Marshall started litigating cases about discrimination in colleges in the late 20s. And Brown versus Board of Education was in 1954.
Right.
I think people forget that it started, 30 years ago. Mary, you had a case, an initiative case, I think, wasn't it, in Riverside?
It was a local initiative, right. In fact, this was one of the first instances where we saw an initiative come out which was targeted to prevent, in this case, people with HIV or also lesbians and gay men from having political rights or having access to discrimination protection. And that was a case we managed to convince the courts to invalidate the initiative several years ago, I think 1991. The first initiative that we're aware of that reached a decision in the courts where the local court of appeal agreed with us and said that this would violate the equal protection rights of lesbians and gay men and people with HIV. That was a particularly evil and reprehensible initiative that prevented the city of Riverside, would have prevented the city of Riverside from, or any person who had access to funds in Riverside from taking any position that would encourage or promote homosexuality. It was a very, very broad initiative. But what was important about that was that it was one step in the right wing's movement towards a host of these initiatives around the country. And what we saw was soon after the Riverside experience, we saw initiatives cropping up all over the country, and particularly in Oregon, the Colorado initiative, Massachusetts, Florida, Maine. And I think one of the things that's so important about this decision is that it finally gives us some direction as to enable courts to unilaterally or uniformly say this is not a permissible course of action on the part of those who don't want lesbians and gay men to have political rights. And I can't tell you enough, it's not just the battle has not just been in the courts. The battle has also been in the organizing in the field. And many people are familiar with the battle in Oregon because there's been quite a lot of publicity and some movies about that, where it really shows how it changes the tenor of a society when you hold a particular group of people up for public appropriation and just opprobrium and to focus on them with the hostility of directed at them through these initiatives. You realize how important it is that we reject those and that our constitutional system be affirmed to reject those kinds of initiatives.
Well, how did the court respond to that initiative in Riverside? I mean, how high did it go in the court, and what did the court do?
Well, we won in the trial court. We won a ruling that the initiative violated the equal protection rights of lesbians and gay men. And then on appeal, in what we would have thought would have been a conservative court, it was a San Bernardino Court of Appeal. The Court of Appeal very clearly came out and said, this is simply unacceptable. What you're doing is to target a particular class of people with hatred in a way that is contrary to that our Constitution, in this case the California Constitution, simply does not permit. And one of the most beautiful lines from that opinion, and I think one that echoes in the decision by Justice Kennedy, is the court's remark, all that it lacks is a sack of stones for throwing. And it really does, I think, illuminate that what reaches to the people who don't necessarily understand our movement, understand what we're trying to express, the gains we're trying to make, the hatred that is so clear and evident in these initiatives comes through to the courts. And in my view, I think they're just horrified by it. I think one of the things that we were very encouraged during the oral arguments of Roemer, the first question Justice Kennedy had off the bench is, there's nothing else like this in our constitutional literature here, because there's never been a case like this before. And that's absolutely right. There hasn't been this kind of, let's get them, and this is how we're going to do it.
Well, there's some false analogies being made, though, that I'd love your opinion on. I actually, when Dan Lundgren, the Attorney General of California, filed an amicus brief on behalf of all the people of California on the side of the state of Colorado in the Roemer case, the losing side, I called him. One of the things you can do as a state assembly member is you can call the Attorney General and say,
and he
hi,
takes your call.
Dan, it's Sheila. And he was in his car, and he took, they patched it through. He said, no, I have to be on the side of Colorado because we've got two problems here in California that I think are related. One of them is Prop 187, and the other is smokers. And, that's the same kind of deal. What do you think about that argument?
Well, I'm sorry, I don't buy it. I'd be hard-pressed to articulate the analogy he's trying to make. I mean, if he's trying to say that the state should have the right to tell smokers they can't, that we can limit smoking in public places, I'm not sure exactly what his analogy is. But typically, what someone in his position, and I'm basing this in part on my limited knowledge of him, but he has, I think, taken the same position that Justice Scalia would have taken, that the conduct that he has stereotypically defined, as John talked about, the conduct that much of conservative America has stereotypically identified gay people as being, the class of gay people as being defined by that conduct, that he's saying that therefore you can't limit conduct if I don't support that position. That's simply not right. We've made time and time again made it very clear that sexual orientation and the process of developing a sexual identity is a very distinct process from what particular sexual conduct a person engages in. And as John very clearly explained, these statutes that they're relying on target all sorts of conduct or very specific acts by anybody, not just lesbians and gay men. And so what he's done implicitly is collapse that distinction. And it's, I think, an apology that is not an apology. I mean, it's complete bunk.
What did you think of Justice Scalia's response to being on the losing side? I mean, it was a 6-3 decision, and he sounded pissy, worse than pissy.
We have always known where Justice Scalia stood on this issue. I mean, this is not a surprise. He's been very clear that he believes that the Constitution should not protect threats to the common consensus morality, what he believes is the common consensus morality. And he's made that clear in some previous cases that social morality should determine the limits of governmental action. But what I think this decision clearly says that the Equal Protection Clause should be analyzed differently, and that's the common consensus of morality, which may be the popular mode, is simply not going to determine how the limits that we set on the government and how they treat individuals. Because if you were going to say that the common morality can dictate how we treat individual groups or particular groups of people, you would be saying that the democratic process we can always determine by majority rule. And by that analysis, we could vote any time of the day to reinstitute slavery. If that was a politically popular thing, we wouldn't be able to protect people from that. And clearly the Equal Protection Clause was intended to reject that kind of majoritarian rule.
The other lovely thing I think about Justice Kennedy's opinion as sort of counterpoint to Justice Scalia's dissenting opinion is that Scalia raised and reiterated every argument that's ever been made against us in a dissent. And it seems as though it's like saying, thank you, now there won't be anything more that can be said because we've just said no to all of that,
and
the
I
six
think
of us.
I share John's perception that the discussion of Hardwick and rejection of the Bowers versus Hardwick decision as determining that gays and lesbians aren't entitled to equal protection of the laws is absolutely the critical step for us in this case. This, rather than, I think we've spoken before, this is our Brown versus Board of Education in a different perspective. We did not seek out the case. We did not bring it to the court and say, look at this inequitable situation, this shouldn't last. We have been assaulted. We were up against the wall. And to tell you the truth, if we had lost this decision, I really don't know where we would have gone to salvage any kind of constitutional protection. And I think that the lawyers who saw Bowers versus Hardwick being used to gut the constitutional protection for lesbians and gay men, time and time again, were horrified at the thought that this particular decision was potentially going to ruin us for years to come. And for that reason alone, this is just an extraordinary decision that really does establish us give us a bedrock from which to work.
Well, it's interesting that in a time when we feel most beleaguered, because the more out we are, the more people who don't like us will have something to react against. It's almost as though it does us a favor. The issues are in the press, in the pulpit, on the floor of the legislature. We're definitely the minority in the middle of the griddle at the moment, and the topic of discussion. Maybe it's just me. I've only done 4,000 radio shows, on our issues, and Roemer was the impetus for a lot of that. Although there have been a lot of other issues. With this great title you have, Skye, Director of Public Policy and Communications. I guess the question I have for you is, do you see out there in the real world, beyond the courtroom in a way, and beyond the floor of the legislatures, some impact in public thinking yet? I realize it's very quick, but from this decision, and is it important really?
Oh, I share both John and Mary's sense that it's tremendously important in more ways than we've expressed so far in this conversation. And certainly, I switch your phrase around a little bit from middle of the griddle to middle of the spotlight, and I think that's a great place for us to be. Light is our friend and our adversary's opponent. They want to perpetuate myths and stereotypes about who we are, what we do, where we live, etc. The more that we're out there showing the rest of the world who we are, where we are, what we do, the more we win. Even if we lose in the short term on some of these battles, and we have lost them. We lost the military battle in the short term. We can come back to that later. For the purposes of our longer term goals, I think we made enormous strides with the military debate, because we had Greta Kammermeyer on national television, a movie about Greta Kammermeyer on national television. We had Tracy Thorn, admirable Americans, patriotic, and this changes the language of our opponents. You have Strom Thurmond acknowledging that lesbians are great sailors. Who would have thought any of us would have lived long enough to see that? So I say, bring on the spotlight. And it's just not you doing 4,000 interviews. We get calls at our agency all the time from press who want to see gay and lesbian couples. They want to see gay and lesbian service members. They want to see, you name it, on any given day. And you're right, I think it's a little too early to assess how Roemer is changing public perception, but it's really a benchmark. I mean, we've been making enormous strides for the last 25 years, but they've been largely incremental and sort of imperceptible on a day-to-day basis. But Roemer coming down in a specific time and a specific day is sort of like, boom. Yes, indeed. This is a validation of a lot of the progress that we've been making, all of us in our various ways, over the last 25 years. So I think it has an enormous significance.
Well, we're going to take a break, and then when we come back, we're going to talk about marriage, the military, maybe the president. Who knows? We'll be right back.
Pick up your telephone right now and call the number on your screen. Find out how you can enrich your family values by learning about your gay children.
We had no idea what the gay community was like.
Learn how these parents deal with their fears about attending parents' flag meetings.
One of my biggest fears was that I would see someone that I knew.
Call the telephone number on your screen right now and see how these parents have taken themselves to acceptance and beyond.
Because that parent does not know the positives yet about the gay community.
Hi, welcome back to Get Used to It. I'm Sheila Kuehl, and today we're talking about the moral impact that the law can have, and the Roemer decision, its impact on a lot of other issues for our community. And Skye, I wanted to continue with what we were talking about. I know you've been involved in the Freedom to Marry Coalition. And certainly since we've had all these anti-gay marriage legislative acts proposed around the country, and now one wending its way through Congress, or perhaps by the time this show is shown having gotten through, we don't know at this moment. Do you see that this, this case has an impact on the way people are thinking about that, or do you see it as kind of a different thing in people's minds from a sort of a discussion of civil rights?
It's a little, again, it's a little early to tell what impact, if any, Roemer specifically will have on the marriage cases. It is sort of a different thing, no matter which way any of these legislative issues go, whether at the federal level or at the state level. We've known from the outset that all these issues are going to end up in the court with a specific set of legal issues. And certainly John or Mary can speak to it more effectively than I could in terms of full faith and credit and a variety of other things. But in terms of the political impact, and I do think there's carryover in this issue, because as John and Mary both pointed out, the language in this case, it wasn't just the outcome, but it was the language that was used in the case, really does sort of lay down the law that people need to think and talk about issues involving gay men and lesbians in different terms. In terms specifically of equal protection and equal rights and equal justice. In the Bowers decision, the infamous Bowers decision, Justice Kennedy's majority opinion was dripping with contempt for our community. He used the word facetious to describe our claims in that case. And we have seen that completely eradicated, or at least relegated to the minority opinion for the first time in our history. And so I think all people in public life are going to look at all of our issues, and they've been coming to this different position all along anyway. But I think again, this is a benchmark that means that we are analyzed, evaluated, and discussed in different terms, and that will definitely have a carryover in marriage and all the other issues that we're dealing with, I think.
But there's an interesting progression here, don't you think? There's a moment in time when public opinion starts to shift, but it doesn't shift on everything. I mean, people were probably willing to say, I guess a person of color ought to be able to keep their job and not be discriminated against, years before we had that movie, Guess Who's Coming to Dinner, which was really about marriage. And so there has always been, it seems to me, it could be ahistorical on my part, but always been a kind of a disconnect between how we treated people in the public arena. Maybe we would start to feel better about that. And the private arena, in which we always felt more utsy about moving too quickly into that. And it seems like public opinion doesn't just flow from a court case, but to some extent even precedes it.
Oh, absolutely. No question.
Like Roe v. Wade, or even Brown versus Board of Education.
And that's, I think, Brown versus Board of Education is a great example. I mean, I don't think anybody in the South was prepared to desegregate schools so that, in 1954. So, and that's an instance in which clearly public opinion was ahead or behind the courts.
Mm-hmm. I think it's clearly an interactive process. And I do think it's important to look at Brown versus Board of Education, 1954. It wasn't until 1967, 13 years later, that the court decided Loving versus Virginia, which said that laws that wouldn't permit interracial marriage also violated the Constitution. It took a while for people to do that. But I think it's also important to understand we are making progress in the court of public opinion. Recent polls that Newsweek had showed that 85% of the American public now believes that it is wrong to fire someone simply because they're gay or lesbian. That's incredible progress that we've made in a very short space of years on that issue. But even on the marriage issue, just it wasn't long ago, it was 2/3 of the public was against us. The latest poll said it was down to 58% had problems. And what one needs to understand is that when Loving versus Virginia was decided by the courts, there were more people opposed to interracial marriage than there are currently people opposed to marriage by lesbians or gay men of our partners. And so we are making very rapid progress, I think. And I do think that this decision does at least get people to start thinking about, well, why shouldn't somebody be able to marry the person that they're in love with and that they're sharing their life with simply because they're the same sex as that person? Why do we have that limitation? Is there a legitimate reason for making that distinction. And what the court set forth was a framework for thinking about those issues that's a more calm and less hysterical way of thinking about what sort of distinctions are permissible for the government to make.
Well, it's a notion of harm, isn't it? I mean, in a funny way, I guess maybe because I'm an anti-smoking person, I think the distinction between those things that Dan Lundgren was talking about relates to some extent to harm. You know, smoking doesn't only hurt the person who's smoking, it hurts the person, now we have evidence to show, you know, sitting next to them or living with them or whatever. So maybe we could limit that in a public place. We limit all kinds of things that go on in public places. But people are hard pressed to come up now with notions of exactly what is the harm of having gay and lesbian people in society saying that they're gay and lesbian. Now, the answer is a moral harm. Now, Scalia was completely vitriolic, I mean worse than vitriolic, in his dissent. So can people still make a distinction between this public sphere where it's okay to work and something about the private sphere where if you recognize that this deepest, most personal relationship is okay, something is undermined? I mean, let's talk honestly and not just like what we think we ought to say. Is something undermined by recognizing our relationships, or what potentially is undermined?
Well, I have to say, I've always had a hard time seeing the other argument, so I'm not particularly eloquent on what the harm is. I don't see the harm. But one of the things that I think is so important is the sea change we've seen between Bowers versus Hardwick and this decision. Bowers versus Hardwick is premised almost entirely, and it is a case brought under the Due Process Clause, which is more about what are the social standards and the traditional concerns of the Bill of Rights. But it is a case where it was assumed, and I think Skye referenced this earlier, that gays and lesbians were to be hated, and that there was absolutely nothing that not just gays and lesbians, but the conduct they engaged in. It was just disgusting, and there was nothing. They shouldn't be recognized for any rights, and it was laughable and facetious at best. Well, what we've seen is that viewpoint is now in the dissent, and what is even more I think striking is Scalia seems to speak from this conviction that he is carrying the moral scepter for this whole congregation group of people out there that he distinguishes from the elite from which the court is derived. It's a really, I've never seen anything like it in a decision where he chastises the court for its elite viewpoints that are decidedly urban. He makes some reference to the fact that these are the kinds of views you get in cities. Whereas he presumes to speak for the rest of American society, and I think he is fundamentally misunderstanding what's happening and not recognizing what's happened over the last 10 years. First of all, more than at any time in our history, the media is driving the boat. It's not the court as much as it once was. I don't think Brown v. Board of Education is, as much as it was leading the nation, I think the media is in some ways leading the nation, and we have in very many ways been able to present ourselves and have people understand and see into our lives through the media in a way that has changed public opinion. And Scalia, I think is entirely wrong about what the unilateral position is of the American public.
But it's interesting from what Skye said, kind of about the light being our friend. The media, the reason why the media has been helpful, I don't think is the other side blames that as kind of the liberal biases and again the elite in the media. But I think it much more has to do with people really seeing who we are. When we've seen again and again that when we come out and when people learn about us, they kind of the myths and the fears that they have start to dissipate. I do agree that that's one of the wonderful things about this decision. The troublesome thing, I think, when it comes to talking about marriage for a lot of people, marriage is a funny thing. It in some ways feels incredibly private, and it clearly for many people has religious overtones to it. And a lot of people confuse this debate with one about whether there should be religious marriage ceremonies, where the religion should be imposed, required to marry people. That's not at all what's currently on the table. What's on the table is whether or not lesbians and gay men should be able to achieve the same legal status and assume the same legal rights and responsibilities as heterosexuals who can get married. And so again, once you start to explain things, I think people start to look at it in a somewhat different issue. That issue is very much a public issue. It's not about private stuff, but people have trouble, and because it's tied up with all of the mythology about marriage and all of the fantasies about marriage. You know, it's so hard to get people to think beyond the wedding. One of the problems I think that generally we have with respect to marriage generally is too many people, heterosexuals principally, don't think about anything other than the wedding. They plan for the wedding and they don't really understand what the reality of marriage is about from a legal status or even from a practical point of view.
But it's also the use, I feel a little more suspicious, I guess, about this, because it's also the use of a kind of scarcity mentality. The arguments against our getting married is that it's going to undermine heterosexual marriage. Now, what that means is, if you can do it, it won't be as important or as wonderful, because that will mean it's not just limited to me, as though it's a country club, for whites only or for men only, or, well, like marriage was for whites only. I mean, slaves weren't allowed to marry. And it's a way you can point to a group and say, you're not human. You can't get married. And my demonstration that you're not human is because you can't get married. So it's kind of this, this circular proof that we will somehow dissipate.
Well, it's a caste system.
Yeah.
But I think that I think that they have no arguments. I mean, I think that argument shows the bankruptcy of their point of view. Once they get past Leviticus, and you have to do that if you're talking about civil law, they don't have any arguments to make. It's been this way for 5,000 years. I know that's not true, but even if it were true, so what? The fact of the matter is, lots of things happened for a long time, and we figured out they were wrong, and we changed them. And I think this is an example of just that sort of case. People like Scalia are beyond redemption, and that's pretty clear based on his dissent and lots of other indications. But the fascinating thing that we found in the year and a half or so we've been working on this, and it goes back to something that you said earlier, that when people actually stop and think about this, I mean mainstream non-gay lesbian Americans, and this is all brand new. I mean, people really haven't had this in the public arena for more than 3 or 4 months in most cases. I mean, it's really just emerged this calendar year. But when you sit with an individual and you can sort of see the light come on somebody's face, and you think, well, what would be the problem with that? And many people conclude, well, there isn't any. I mean, Joe and Jack are in their house down there. They're got a mortgage. They're mowing the lawn, and they're married. So what? I mean, of all the problems there are in the world, that, if you perceive that to be a problem at all, has got to come way down the list for an overwhelming number of Americans. That's why I'm optimistic in the longer term about this.
Well, I'm sort of a glass half full kind of person too. I feel as though the movement is moving along just as other movements have. We've made some gains. We have some setbacks, and one of those is the military. Let's talk about the military.
But I just want to go back before we go to the military. I mean, just think about that statistic that John cited before: 58% opposed to same-gender marriage. Well, think about that. This was a notion that would have been completely unthinkable. Laughable. In fact, Gary Bauer and others are trying to say it's still laughable, but it's not laughable if 58% say, yeah, but I'm against, but 42% say, well, no, I'm not, or, I don't care. I mean, that's a greater percentage of the vote than a lot of Democratic candidates for president.
Because I think 2 years ago it was more than 2/3, John.
Oh, yeah.
It was like 75% or whatever.
We've seen that just as in a lot of other areas, and we've seen that come down. And the other encouraging thing is in all these polls that the folks who are more likely to be with us are the younger folks, and the older folks whose attitudes were formed pre-Stonewall or pre-Depression are the ones who are the most hostile to our
I actually think there's a third dynamic that Scalia doesn't recognize. Yes, the cities have attracted many gay people because they are able to lead open lives more easily. But the reality is that there are a lot of people still in the so-called non-urban, central urban areas And the other fact is a lot of us came from those areas and we have family there, and family are dealing with the fact that their loved ones are coming out and they're having to rethink all of these issues, even if they live in, I don't want to say the name of a town, it's inevitably going to offend someone, but small towns, rural areas, everywhere. There's, I think, a much broader perception, and also the national media, again, is national now. It is not limited to the big cities.
Well, and also in the small towns you see, pride festivals, a sort of brave little band of people with, rainbow rings around their necks having a 30-person kind of pride day, and those are really courageous people.
Absolutely.
But doing it and saying, in this town, in your neighborhood, we're here.
Teenagers in Salt Lake City.
There you go.
Yes,
Oh, pretty
those
major.
teenagers, and the straight teenagers who bonded with them and said, I don't think this is as big a deal as everybody says it is. Let's walk out of school and protest, which is.
But that's, of course, what frightens Scalia and his ilk, because they are convinced that if they don't do something fast, they're going to lose the war. And they see it as a culture war, and he says so very clearly. And, in some respects, I don't see it as it is a cultural change. It's not a war, it's about an evolution. And this decision is an essential building block in that.
Well, Mary, you also had a couple of military cases early on too.
Couple?
Or was there just one?
No, there were several. There were several.
More than a couple. Is that a distinguishable area? I mean, we've heard about deference, to the government on military issues, and we've heard about this sort of special notion of unit cohesion. And in Roemer, they said, you just need a rational reason to distinguish between gay and straight people.
Wait, no. They said at a minimum you need that. They didn't decide the issue of what level of scrutiny applies.
Well, I certainly don't want to impact it.
Yes, and you don't want to concede that.
I know that the 9 are watching this show. The question now that we're on in Washington. So I certainly think it should be strict scrutiny if you're watching. But let's say at a minimum, do you see a difference in the military cases and the way they might approach them? Or maybe you want to talk about Dusty's or other cases and what's happened.
Well, there's no question that they're going to be significantly helped by the decision, because the decision has confirmed that for instance, the Bowers versus Hardwick case does not undermine the right to equal protection. And as we've been saying, at a minimum, the government has to show a legitimate reason for its actions. And consistently, if you look at the evidence that we've been presenting in court in these cases, it undermines, number one, the rationality of the regulation, because frankly they treat different people differently for different reasons, for the same reasons that make no sense. The same conduct doesn't simply warrant the same punishment. But then also, it's very clearly saying, and this is why this case just means so much to those of us who have been litigating constitutional cases. It very clearly says you can't act out of animus towards a disfavored group. We've been saying that for years, and this case shuts the door on those who would say Bowers versus Hardwick says we can make the conduct criminal, you're defined by your conduct, therefore we can do anything we want to you and it doesn't matter because we hate you. Now interestingly, 12 years ago, Justice Kennedy, when he was on the Court of Appeal, wrote a decision in a military case upholding the regulation on the basis that a single affidavit that said, well, it's rational because there are many people in the military who hate gay people. That was his reason for upholding the regulation. Would he do that today? I don't know. I think that would be a very interesting question.
Well,
We hope not.
It's true. Well, what do you think about this notion of deference to the government and unit cohesion as a reason? Because I'm sure the military would say it's a rational reason. Is unit cohesion the same as hatred?
Well, I think we're going to find that out within the next couple of years. There are several important cases wending their way up to the U.S. Supreme Court dealing with challenges to the don't ask, don't tell policy. The courts have said that the military is entitled to somewhat more deference than in their decisions than other aspects of the government. But they've also very clearly said that the military is not exempt from the Constitution, and that people who enter the military do not give up all of their constitutional rights, particularly with respect to the issues of equal protection. And I think it's important to recognize that Don't Ask, Don't Tell, perhaps most clearly as a policy, shows that the government is treating one group of people very differently than another. Heterosexuals in the military are allowed to say what their sexual orientation is. Lesbians and gay men are not allowed to say what their sexual orientation is, or else certain things will happen that unless they ultimately disavow that statement and what it means, they will be kicked out of the military. And the military, I think, will have to come up with a legitimate reason. And what is yet to be understood for sure is whether, when the court said animus is not a legitimate reason for treating people differently, whether they will apply that exact same standard in the military, and what they really mean by that. Unit cohesion is the kind of rallying cry that Sam Nunn and others used to defend this policy. But when you really start to ask people, what does that mean? And I think that's kind of what our job a lot increasingly is kind of hearing phrases that are used against us and really asking people to look at that a little more clearly and to think about it and to explain it. And when you do that with unit cohesion, you see that all it really means is a concern that some heterosexuals don't like us, don't want to be with us, are afraid of us, don't understand us. But all of those things sound a lot like animus.
Well, but you know, in the military, as with police, this notion of whether you're going to get backup, this notion of whether you can trust your partner, they elevate it to a standard above just, I don't like so-and-so and I don't want to sit next to him, or I don't want to, be in the same room with him. And one of the things that's interesting about the way the court weighs whether something is rational or not really is their own gut reaction to stuff. Remember in Rosker versus Goldberg, the case about registering women for the draft, the lower court said, can't find a rational reason not to register women for the draft because they could be drafted. There's lots of slots that they can fill, even though they were statutorily barred from combat. Couldn't think, the Department of Defense, all their testimony went the other way, right? And it said, we can use them, we want them in the volunteer army. It got to our Chief Justice, however, who wrote the opinion at the Supreme Court, and suddenly there was a rational reason, because everyone in the military had to be ready for combat at every moment in case we had a nuclear war, and everyone had to go into combat. And since women couldn't go into combat, they couldn't be drafted, and they didn't need to be registered to be drafted. Please go home.
Amazingly, though, they used existing inequality to defend inequality. It's one of the ironic things about that. I think we won't know for sure what the answer is going to be in the military until the court decides those cases. But I think that this decision gives us great hope and a lot of promise that it will come out the right way.
Well, what case do you think is going to, there are a number of military cases kind of swirling through the system. I think there's a National Guard case here in California.
Yeah,
what other cases are on their way?
The Thomason case from Virginia.
It's the furthest along.
The Able case, which is a Lambda and ACLU case involving 5 different service members from New York. The Phillips case, which is from Ninth Circuit. It's out here. And there's a Watson case.
There's a Rickberg case. I think there are 8 or 9. I was talking to the Service Members Legal Defense Network just yesterday, and I think there are 9 federal cases challenging the Don't Ask, Don't Tell policy, under the new policy explicitly, that are working their way up.
Do you think we're likely to see a split in the circuits, which would
lead
the court to actually not on Don't Ask, Don't Tell, not yet, but we're very likely to see the kind of circumstances where the court finally reaches down and says, we're going to decide this once and for all. It's not far away. What I'm very happy about is that the Colorado case got there first.
Yes.
Yeah, it's really important what gets there first.
Very much.
Well, in the court of public opinion, Sky, what's the buzz out there on the military stuff? It doesn't seem, nobody's calling me and saying, now how do you really feel about, lesbian sailors?
I think it's last year's hot topic, or 2 years ago's hot topic, so we don't get a lot of calls, and people do recognize it in the courts. And I think most folks on both sides anticipate that the courts will ultimately resolve it, that it's not going to be a congressional issue again, certainly not anything that this administration is going to bring up in any way again. So they're busy defending this and doing their best.
Though it's in the House budget bill, they tried to resurrect the old policy.
Right.
It's certainly that at least some people in the Republican Party won't give up on it.
I think Newt's in there too.
No, I know. Well, I mean, he talks around it, but it's basically Dornan, and that's not expected to go anywhere. So I don't
well,
think
one of my colleagues, George House, tried to put an amendment to the budget in our House, Mr. House, in our House.
Under a delusion.
You know, that's really that would have forbidden any expenditure for anything that would have somehow portrayed gay and lesbian life in any kind of a positive way. And I'm happy to say it was defeated narrowly, but it was defeated.
That actually is the same kind of action that I think the Roemer case would absolutely invalidate.
I had a chance to spend some time working on the military issue explicitly in 1993 when all the stuff was going on in the Congress. And we had ongoing conversations with people in the Pentagon, of course. And interestingly there, the generals, the admirals, I think almost all of them recognized that sooner or later this policy was going to go. Several of them even acknowledged in private conversation that it was just a matter of time. And there was a real sense that the tide is running the wrong way on this issue, wrong way from their point of view, right way from our point of view. And they were just trying to hold it back for a little while, so it wasn't under their watch that this terrible thing happened.
Well, I guess we only really have about 30 seconds remaining in the show. I don't know how the time goes by so fast. There are probably 3,000 or 4,000 other issues we could talk about, but it feels to me, Sky, like what you said about the tide turning is really true, and whether the media is deeply enmeshed in this, whether the court still has the kind of moral suasion that I think we've always thought it has for hundreds of years, where, oh, they said it, and it's not only the law, there's something beyond it just being the law, it's right. You know, it's an announcement of what is right, and Americans kind of aspiring to being on the side of fairness and justice and stuff, and I think it makes most people feel good when they come out with something like this. So thank you all three very, very much for being here with us. Thank you very much for sticking with us through this. I hope this was as much fun for you as it was for me. And remember, no matter when anyone says to you that anything's wrong with this community, you say, we're here, we're queer, get used to it. See you next time.